Okay, now, Mr. Patterson, are you ready for anybody or?
Judge, if we could do all the cases at the jail?
Okay, let's start with the first one. And is that still Compass Whittle?
Please.
We are on the record in BU 2021 CR 497, State of Kansas versus Zachary Enoch Compass Whittle. Please announce appearances.
Gary Regier on behalf of the state.
Your Honor, Darren Patterson appear on behalf of Zach Compass Whittle. Mr. Whittle does appear from the Butler County Jail. Judge, this is a case that is set for jury trial on Wednesday. I would also tell the court, though, I have filed a motion to dismiss for speedy trial. I have had some emails with counsel, or not Mr. Regier, but with counsel assigned to the case, and have suggested that maybe it should be dismissed, but that's as far as I got. We have filed a motion, though.
All right, Mr. Regier, whose case is this from your office?
Your Honor, this is a case where the information was filed by my colleague, Ms. Cheryl Pierce. However, I am in a position to address the motion.
All right, please proceed.
Yes, Your Honor. The state had previously on Unrelated Matters, the state has addressed its concerns about how to appropriately seek justice for alleged victims in light of the court's current court calendar. However, in this particular instance, it would appear that speedy trial has run in this case. Again, the state does not make this response lightly, again, with the state's continued concerns about seeking justice for alleged victims in light of the court's current calendar. However, it does appear that speedy trial has run in this matter.
Well, now 5/11/22, defendant was here, it looks like, and we set it over for July 18th, and the defendant failed to appear July 18th. Mr. Patterson was here, but the defendant failed. So any time there would not count towards the state. It would count towards the defendant because the defendant failed to appear. He apparently got arrested and was in Sedgwick County Jail May 17th, which time he failed to appear. He'd been in the Sedgwick County Jail for almost a year, so perhaps that's why he failed to appear previously. The time still is counting towards the defendant. August 7th, attorney requests a continuance as he needs to speak to the defendant more about the case. They did not have a good phone number for the defendant at the defense attorney's office. State did not object to this continuance. That time still counts. So far, all time up through August 7th counts towards the defendant. October 23rd, defendant and attorney needed more time to discuss the facts of the case. No objection from the state to the defendant's request for continuance. Time still counting towards the defendant. January 29th, 24, next hearing, defendant failed to appear. Bond forfeiture bench warrant ordered. Time still counts towards the defendant. June 10th of 2024, defendant appeared from a residential custody facility in Sedgwick County. Jury trial was requested. The matter was set for pretrial 9/30 of 24. Jury trial set 10/2 of 24. Judgment on bond was granted. Judge ordered the defendant to turn himself in, so he was, even at residential custody, he failed to appear in person because he was avoiding a warrant. Time still counting towards the defendant. June 12th of 24, a bondsman called about the case, said he was planning to attend Monday, but an emergency came up. The bondsman asked for a rehearing on the motion for judgment. You would like to avoid paying the $5,000 ordered. Says that the defendant has been a very good client since getting clean and he can turn himself into Butler County as soon as possible. Next hearing, June 17th of 24. Bondsman Webb appeared. Bondsman requested to set aside the motion for judgment on bond, denied, but the judge would reconsider the motion for judgment if the defendant turned himself in. So he's still on the lam, as the saying goes. June 21st, he was scheduled on the docket, but the county attorney said remove him. He'd been scheduled for June 24th at 9 a.m. on the misdemeanor control with Judge Webster. So that happened on June 21st. Mr. Patterson, attorney, and Tyson Case bondsman present. Defendant requests that the bond be reinstated, and the judge did grant it. But then 9:30, defendant failed to appear again. So far, I don't see any time counting against the state. February 3rd, 25, defendant was present via Zoom, Mr. Patterson via Zoom at a separate location. Plea negotiations and sentencing recommendations were outlined and accepted by the court, but bond forfeiture, bench warrant, no bond hold. Apparently, defendant failed to appear again. March 19th to 25. Looks like defendant may actually have reappeared finally. That's March 19th to 25. Set for misdemeanor control, May 12th. So May 12th, the defendant was present. So there's some time against the state, March 19th to May 12th of 25. That's this year. Set the jury trial for 9/29, which is today, pre-trial. All right, counsel, as I go through that, what did I miss that says that the speedy trial is run?
Judge, I can announce that.
Okay.
Your Honor, this is a case where, as the court noted, there were several non-appearances, and we had jury trial scheduled one time previously that he did fail to appear. I would tell the court that pursuant to KSA 223402D, that in the case where a trial has been set and he fails to appear, but then later does appear, that in this case, the 90-day requirement would kick in. So when he showed in March, or very latest May, that there was a requirement by law that he be set for jury trial within a 90-day period. He was not. Therefore, the speedy trial would have lapsed.
All right, but that's if he's in custody. Did he remain in custody that 90 days?
That's not the rule, Judge. And again, I'm asking the court to refer to KSA 223402D. That is the specific subsection that deals with somebody already set for trial who fails to appear. When they then reappear, they're supposed to be set within 90 days.
Mr. Regier, you agree with that interpretation of the law?
Your Honor, it would appear that counsel has accurately referred to the provisions of KSA 223402 subsection D, and I think the state will respectfully leave it at that.
All right. Well, okay. So are you counting from when he showed up May 12th of 25, Mr. Patterson?
Either one, Judge. I think the statute says when he reappears, it shall be set back on the jury trial within 90 days. I think that would have been March. But even if we don't count March, April, and go to May, the 90-day requirement still put us in August.
All right. But if the court did not have available another jury trial day for 30 days, that you don't think that would extend the period? We couldn't get him in August, but we could get him in on September 29th. You don't think there's any grace period there?
It may, Judge, only if the court would make that determination on the record, state so on the record, and it would be done before the expiration of the 90 days.
So, counsel, the interpretation you're presenting today would suggest all defendants disappear for a while well, maybe not. As the state informed the alleged victim of this domestic battery that this motion is on for today, or that this defendant is appearing today?
Your Honor, I do have recent notes insofar as correspondence between my office and the alleged victim are concerned.
So the victim knows that the proposal is that he walk away today free of responsibility for this alleged domestic battery.
I would need the opportunity to review further, Your Honor, as I was not a personal party to those prior communications.
I see. That would have been Miss Norris. Okay. Well, I am going to have to review 223402D because I don't recall that provision, but I've never had it come up before in all my years either. That if they disappear, if they fail to come, let me make sure I understand the argument and the interpretation. If the defendant fails to show up for jury trial, Mr. Patterson.
Yes, Judge.
And then when he comes in later, here I am, I've decided I want to come, then I have to set him within 90 days. It totally sets a new clock and does away with the other one.
Yes, Your Honor. And further, just for the court's information, I would tell the court from a review of the time he spent in jail and contacting the jail for purposes of that, receiving that credit for time, he's actually served the longer than the entire sentence that the court could give, even if he's found guilty. I think that could have weighed into what's going on here too.
And again, Mr. Regier, it's your understanding that the attorney on this case for your office agrees that he should be released for speedy trial violation, right?
That is the state's understanding, Your Honor. Additionally, what I would tell the court is that count 1 of this matter does appear to be charged as a Class B misdemeanor. It would appear there was a first appearance back on March 19th before Judge Hart, where the defendant did appear in the same fashion that he does today.
In jail, in other words.
It would appear so, Your Honor. So, in either event, the state does have its would have its concerns reiterate on the record in light of the speedy trial provisions in the court's current calendar. And again, the state does not make these statements lightly, but for all intents and purposes, based off the state's reading of the statute, it would appear that counsel is correct in suggesting that speedy trial has run in this case.
All right, at the joint recommendation, I will so find, but I want the victim, I'm going to order that the victim be notified post haste. I don't want him to just show up and say, here I am, I can do whatever I want now. And Mr. Patterson, present me a journal entry today, if you can.
Yes, Judge.
All right. Motion granted on joint request of the parties. Defendant released, case dismissed. We'll be in recess on Compass Whittle.